Litigation Psychology Podcast brought to you by Courtroom Sciences, Dr. Steve Wood. Today's topic, medical malpractice cases. This is a topic we haven't talked about as much as we should on the podcast. It's a lot of work that Bill and I do in this space, so we wanted to make sure we need to focus on it more. And to help me out, I got two attorneys today, both from Hall Booth Smith. I have Jackie Clark. Jackie she's a partner in the Atlanta office. Jackie, how are you?
Hey there. Good morning, Steve. How are you?
Morning. I'm good. Thanks for coming on. And also I have Jason Hendren. Jason is also a partner. He is in the Rogers, Arkansas office. And he is, for those who have watched the podcast, listened to the podcast, he is friends with our good friend, Baxter Drennan too. Baxter was able to get Jason on here, and I'm excited to have Jason on. Jason, how are you?
Doing well. Thanks for having me.
Yeah, I'm happy to hear and excited to hear from you guys on a topic, like I said, that I enjoy, and we just haven't focused on enough. But Jackie, I do want to start, when we talk about a lot of cases in the med mal space, a lot of different injuries, a lot of different causation theories, a lot of different, aspects of it. But in your experience, what have you found to be really kind of the toughest type of med mal case to try?
Yeah, there's kind of a saying in the med mal part of our litigation world that that you're not really a med mal attorney until you've tried a really bad birth trauma case, or at least worked it up to the point where you end up surprised at the end with some nutty life care plan that you're is kind of like the icing on the cake of what can be very difficult, very long cases that change over time, because there's always there's a potential for an evolving injury in a young child that you're kind of always checking in on, so those can be very, very tough. Wrongful death cases can be tough, and paralysis cases can be tough. And those are all because the damages are very difficult to project from the front end. And oftentimes the providers did a very good job, truly. And that's one of the reasons that Jason and I love what we do, is because you feel that, deep down, legitimately, there are folks who are out there trying to do the best that they can. So those are some of the bigger categories for damages, but also can change over time in dramatic ways, where we have a duty to make sure our client knows that, and we're kind of always assessing that ear to the ground evolution of the case.
There's also a lot of sympathy in that case too, you're dealing with, right?
Yes.
Especially with bad birth cases. You have a little child who, may have permanent brain damage, and it's really hard to put that in front of a jury and tell them, don't let sympathy, bias, prejudice weigh into your decisions. I mean, good luck with that, right? Yeah,
certainly when you're looking at the jury charges as you're getting ready to go to trial in whatever state it's in, there's always one on sympathy. There's always one where jurors, even in voir dire, when you're first picking a jury, or we like to say striking a jury, because I wish we actually got to pick a jury. But when you're doing that, and in certain cases, when you read that jury charge and you're thinking through how it will play, it changes dramatically. And those are the hard ones.
Yeah.
Those are the hard ones. So
yeah. Jason, has that been what's been in your experience, kind of the more difficult ones? Is it similar to what Jackie, or you have some other ones that you found to be difficult?
Yeah, absolutely. I think Jackie's spot on. Birth trauma is always worrisome just because of the increasingly high life care plans. I rarely see one now for under $20 million. It's usually quite a bit more than that. The things that have been difficult over the years for me have been clients who are very, very reputable, really good hospitals, specialty hospitals, children's hospitals, where the juror, you have to be mindful that the jurors are going to be harder on those facilities that they know well, that they think are, top notch. They're far less forgiving of, ordinary type of, reasonable care. They expect things to be done really well. So I always counsel clients who are at, very prestigious facilities. This doesn't necessarily make it better. Your reputation will help you here, but we have to be mindful of the fact that they're going to expect more from you also. And so those cases can be very difficult as well, because often, when you're dealing with the children's hospital, they're typically getting a transfer late in the game from another outside hospital. And then, you're kind of left with a really, really bad situation at the very end. And it's often where you get kind of left holding the bag if the result turns out to not be good ultimately, and then you're put in a position of having to defend yourself about what happened earlier and if they'd gotten to you earlier, those sorts of things. So those can be really challenging as well.
I think you bring up actually a good point that I've seen before is the same thing when you're saying about how you have a hospital in a community that has a really good reputation, that when things go bad, things go quote unquote bad, it's like jurors will say, gee, this place is so good that if it went bad, they must have really screwed up, because I don't expect them to screw up. So if they did, then they must have really screwed up. There must be some validity to the plaintiff's allegations, right?
That's the danger. Yes.
Yeah. And that's one thing I think is counterintuitive, and people don't think about it a lot because they think that reputation will help them, but it doesn't. So that's an excellent point. I guess one of the other things too is, what about, have you guys noticed like traumatic brain injury cases are difficult? And the reason why I bring that up is I think because a lot of times there's a lot of focus on the Glasgow coma scores and whether or not it's a 9 or 8 or a 15. But I think a lot of times there's wiggle room about plaintiff's counsel can say that it's the invisible injury, or you can't see it, or they're able to work it up differently. I mean, Jackie, what have you been experienced on that?
Oh yeah. TBI cases are so for the same reason that birth cases with hypoxic injuries can be an issue, because there can be varying interpretations. TBIs are not even the next category, an analogous category for adults, and that's not just in the med mal sphere. That's in the trucking industry and big MVA cases and any real personal injury cases. I had a trial 4 or 5 years ago in federal court where someone was alleging a TBI and asked for 8 figures to the jury, and there was no evidence. There's no objective evidence on the MRI of any changes to her brain, but she was alleging personality changes. And the plaintiff's attorney used, and the plaintiff's bar has so many experts who will talk about that imaginary injury, and they also will. There are just so many subjective changes, like mood changes and personality changes and sleep deprivation and things, some of which are just like a natural part of either anxiety or depression or getting older, and can be lots of other causes, So yeah, that TBI cases can be very tricky, and the plaintiff's bar has lots of neurologists and neuroradiologists and other very specialized physicians that jurors will go, well, why would this person, not be giving me an objective interpretation? But you don't have the same kind of objective findings on an MRI. And of course, with NFL concussion injuries in the last 10 years, and those being so publicized, the plaintiff's bar takes that kind of literature and those kind of things where you can have over time injuries, which are really very different than what we're dealing with, but they can use those to explain the brain in a way that people can understand, jurors can understand, and relate to that science. And a lot of it is dubious when you actually get down in the weeds and when you actually look at it, and it really should be showing on most imaging, so it's a hard argument to defend, because you're going, well, what is, your comparison of your mood, there's obviously an incentive to always to drum up damages, but when it comes down to somebody's brain and their personality, it gets a lot more sensitive of a topic, and how you cross somebody like that, right? I crossed that plaintiff on the stand because the partner at the time that I was working with had just crossed experts for 4 days, and she was a mom. She had 4 kids. And so having the right person to ask the questions so that they come across in a way where you're eliciting as much evidence to the jury of the legitimacy of the damages, that can be a real strategy call, on who does that and how those questions are asked, because you certainly don't want to beat up a plaintiff that is alleging that they're brain injured and they can't answer questions the right way, right?
Right. Then he just gets seen like you're piling on them, right?
Right. Exactly.
Jason, what's been your experience with traumatic brain injury cases?
Very similar, and this is going to dovetail into one of the other topics that we may address, but, traumatic brain injury cases made me a firm believer in counter anchoring, because the damages are so intangible. but for all the reasons that Jackie said, and I would echo all of those. But for that reason, it's that much more important in those cases to be able to show the jury, here's what reasonable, going back to the instructions, we talked about the sympathy instruction, we talk about the instruction of, your damages in this case have to be reasonable and fair compensation for what is going on with this patient. And I think you've got to be able in those kind of cases where the damages are so scary to lay people and so intangible and hard to pin down in terms of an exact amount, you've got to have a reasonable number to give them so they don't just out of fear say, well, we don't know what all is going to happen with this person, how long they're going to live. We don't know what's going to, be their needs, et cetera. And if you can come in that situation, and you have to craft it the right way, of course, you only get to damages if they've proved negligence and causation. But if you get there, this is what it would actually take to care for this person reasonably, for what they're going to need. And I think that is all the more reason to have the right damages experts on board to be able to show, hey, we take care of people like this all the time. Here's what they need. Here's what the costs are. Those kinds of things, so you can, at least to the jury, take some of the fear and the unknown out of it and say, this does happen. We do have people who have injuries like this, and they are well cared for, and this is what it takes if you get to that. Now, you don't need to get to that because we didn't do anything negligent, we didn't cause damage, so forth. But I think in those kind of cases, it's extremely important to be able to put something in front of them so they don't come back to you later and say, well, the judge instructed us that we had to follow the evidence and base our decision only on the evidence. And the only evidence that anybody gave us on damages was the plaintiff. And I've seen that happen. And they'll sometimes try to say, well, we gave you a discount. We didn't give you everything they asked for, but it's still a really high number.
Yeah.
And that's why you want to at least give them something that's a lot more closer to what you think the real number should be, and at least give them a chance to go with that one, or get down toward it if they're going to go against you ultimately on negligence and causation.
Yeah, Jackie, I know that, we kind of have had conversations offline, and, other times I've talked with attorneys too, where it becomes a question of, do we or don't we offer up a number? What are your thoughts on offering up numbers, and especially in med mal cases too, when their gut reaction is, well, we didn't do anything wrong, therefore it should be zero?
Yeah, I think, from the beginning, you have to be thinking about that. I think you have to think about that as you're doing discovery. And I would say and there's no formula. I think generally though, if it's a case that could go really, really sour, if there are big angering factors that jurors may get so angry that, you have 2 or 3 holdouts that are not going to give less than 8 figures, right? If you've got that situation, or if you've done a mock trial and you've had a few say that, then you need to think really hard about providing a reasonable alternative picture for damages. And that's often best done through some credible experts who can provide, who can either look at what the plaintiff has done and has given in discovery and kind of go through it and explain the things that would, for example, be necessary anyway. And so those are not a reasonable damage to give. So like we've had cases where they are including in the life care plan sort of routine that, doctors, every person should go to the doctor once a year. Every person should go to an eye doctor. So what are the additional things? This is medication that the patient was already taking before the injury, things like that, where you can kind of like cross off. And what's good about that too is that it makes the jury skeptical of what they're being given. They're not just being given an alternative picture. They're skeptical of, hold on a second, are they really asking us for too much? And anytime you can kind of highlight without pointing the finger, the greed of the plaintiff's request, and plant those seeds of, we're the reasonable ones here, not just in the care that we gave, but if you decide that this person, because they often do want to take care of the person, right? Jurors often want to take care of the person, and they'll look at that and they'll work back from that. And if they can't ever get to liability, that's where we get defense verdicts, and we're very, very happy, right? But if they can find some reason, but they can give you, a number that actually will take care of that person, that's probably a number we've been considering anyway. And so like in the case I was talking about before, the jury came back with a question and said, what were her initial medical bills? And we knew when they did that, like, this is great, because that's what they ended up awarding, which was an objective win for us, and it's because and one of I think the important inquiries there is, what is this person's life like now? So if it's an adult, what is their job now? How is that different from what they were doing before? Is that different because they were somebody who was going to change careers anyway? Is that somebody, in my case, we had a school nurse who ended up starting a farm where she made goat milk soap and would go to, kind of fairs on the weekend. And she made a lot of money doing that. She made way more money than she did as a school nurse, even with her traumatic brain injury that she alleged, right? So if you've got pictures where you can show the jury, hey, this person is doing really well. Jurors love when someone has overcome adversity and they're doing well. And if you can paint that picture, I think that it's reasonable to say, like, hey, they're doing well, and this small amount, if you do get to this phase, will take care of them. Right. And so you don't want to be stingy, but you don't want to give them the option of 8 figures or nothing at all, because a lot of jurors don't want to choose nothing at all. And you'll have 1 or 2 holdouts that go, hey, this seems mean to give them $0. And we hear that in mock trials all the time, right? That they skip right to damages and then they go back and figure out how to get there. And they're not supposed to do that, but they do. And it's just rationalizing. And amongst a pool of people, there's, I think, a psychological need to not find the middle. Not everybody wants to do that, but at least consider concessions, right? And if you've got 0 or something enormous, it's just wise to consider having something that feels like you're going to take care of that person.
Yeah, I think that's a good point, Jason. I think it goes back to, it's one thing I was thinking about, is you always have to be careful on alternative damages to make it so that jury doesn't think you're trying to lowball. Like we hear all the time, right? The defense is trying to lowball and plaintiff's asking for too much. Defense is lowballing. We'll try to find something, but you can go too low in some instances on the defense side and really piss jurors off, from what I found. Is that kind of what your experience has been too?
I think that the general notion that scares defense lawyers a lot is, if we talk about damages at all, will the jury take that as a tacit concession that they might have done something wrong on negligence or causation? And I think that the science behind that, Jackie and my partners have done quite a bit of study on that. And I think that the answer to that is no. They're not just automatically going to think you're conceding in any way if you go ahead and argue damages. The thing to keep in mind is that most of the time, the defense counsel in the case are going to be better prepared. They're going to make a better presentation than the plaintiff's counsel. They're going to build up credibility with the jury throughout the case. And so even if the jury ultimately decides, say, look, we like you, we like your client, but boy, she zigged when she should have zagged, and it caused a problem. I think that the credibility you've built up putting on your case can help you when they say, but, we trust what you're telling us. Your presentation's been good. It's been credible. Here's what you're telling us on damage. We're more likely to go in your direction. And I think the science, to the extent we have it on that, proves that up, that they're more likely to go with our number or get closer to it than they are for the plaintiffs. So I don't think, most of the time, I don't think we're going to get accused of lowballing as much as plaintiffs are going to be accused of highballing, if you will.
Yeah.
But in the right case, with the right amount of damages at stake, you got to use every arrow in the quiver, because you're only going to get one shot to influence what their number is going to be. Yeah.
And I want to move on to another topic. You said something, you kept talking, you talked about the science, and we've talked more about life care plans and that. I guess the question becomes, in a med mal case, a lot of medicine, a lot of experts come in, a lot of new terms, and I guess, Jackie, the question becomes, do jurors, have you found, do they understand the medicine, or does it take a little bit of work to get them there to understand all the different aspects that they're being talked about?
So they usually don't, is the answer. And I always when I try to get a case, I try to make a list, and this is so silly, but I try to make a list of what I had to Google, and I think that's really important, because you can lose that as a case goes on 2 or 3 years later. When you're presenting it to a jury, you just know how to pronounce every part of the small bowel, and and of course, because we've done med mal for years and years and years, we know more of it. From each case you learn more, but especially in like complex surgery cases or things like that. But even in birth cases, right? There's a lot that I, as a mom, assume that other like women on a jury would maybe know, but that in talking to my friends, I'm like, they don't know any of this, even ones that are recent moms, or things where you just assume that they do that, because the way attorneys process things and the way we're kind of inherently curious about things like vocabulary, and law school is that way. You get in there and you get hazed by not even knowing what the words mean that you're supposed to be learning, and so yes, we have to be very careful not to patronize jurors, but also to make sure we're always kind of educating them. And we do that through lots of different tools, through demonstratives, through exhibits, through excellent experts. If you get an expert on the phone and it's your first call or your first use of that expert, and they're already saying, okay, well, let's take this back, let me tell you how this part of the body works, or let me tell you what this normally looks like at a hospital like yours versus a rural hospital, and they're making those distinctions for you, that can really help build it in. But yeah, jurors always need a vocabulary lesson, but they also don't. There's always this there's a distrust, I think, an inherent distrust of attorneys in the room as opposed to witnesses. They always say that a juror is way more likely to give the witness the benefit of the doubt. So we are always building trust with jurors. And one way to not build trust is just to assume everybody's stupid, right? You want to make sure you are talking to them. But of course, there are multiple levels on every jury. You've got folks that didn't graduate high school sometimes, and you've got folks that are doctors or have PhDs or are nurses or are very familiar with the industry. And of course, we love having folks who have healthcare experience or who are most of the time. Now, you have to be careful with that, right? You still have to flesh that out. You don't always necessarily want a nurse, because it depends on their views on other things too, and how likely they are to actually consider the standard of care in this case and things like that. You don't want them to skip your presentation because they have experience. But yeah, you do. Definitions are important, but I would say that they can get really boring too. I mean, you can lose somebody quickly by saying, let's go through the basics of blah, 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 so that is not an exciting narrative, and it's not one that holds them in. And that's not always the most important part. But visuals are huge. We've got a whole war room in Atlanta of different body parts, different, and it just seeing how they all work. A lot of jurors are very visual people, so even from day one in our reports, we like to include like pictures to our clients to explain, hey, this is what this looks like, so yeah. And sometimes a medical illustration is helpful, but sometimes a real picture is helpful, because medical illustrations are not what the body actually looks like. Those are just to learn the anatomy, right? And the real picture is what the surgeon is dealing with, so plus a field that has all sorts of other things going on in it. So yeah, it's so important for them to learn the parts, but it's more important for them to learn like how they work and the difficulties that they present, right? Especially if it's a surgical case. And then like cases like baby cases, like a shoulder dystocia or other cases where physics matter. So then you're not just explaining vocabulary of the parts, but then how the parts can be problematic inherently, right? how like a pelvic bone and a baby's skull and the shoulder can become a whole physics problem. And so experts are huge in that. And the more you can have an expert who you get a 2-for-1 on good vocabulary that's relatable, the better. We don't always have that. Often that's our job, to become kind of the educator as we're telling the story, for sure. So
yeah, I think that's one thing, to your point, when you were talking about experts and being educators. I think that's what you need to do more of, educating versus talking at. And you need to find those experts that are willing to or able to engage with the jury and be the teacher versus be the lecturer, right? And lose them. Jason, I want to move on too. We had talked earlier about things that can, and difficult cases, things that can make jurors upset. I think one thing that we commonly see, I don't know what your experience has been as far as that kind of idea where you having multiple healthcare providers, whether it's a doctor and a nurse, where they're both named in the lawsuit, or there's some both have involved in the lawsuit, and you have them wanting to point fingers at each other and one trying to throw the other one under the bus to try to protect themselves. Like how's been your experience? And then I guess really, how do you handle that and how do you approach that?
It's a significant issue, and it's one that the plaintiff's lawyers try to exploit whenever they can. Obviously, they're adding more and more defendants. I've had cases where we've had 50 or more defendants, including every individual nurse who rounded on, or took care of the patient for the 10 days or 12 they were in the hospital. And what I routinely teach, when I teach at the nursing schools is, as soon as you start doing that, the value of the case goes up and the defensibility of the case goes down. There's just no other way around it. And we spend a lot of time, if we're smart, talking with the co-defendants' attorneys and saying, okay, here's how we need to, work through these issues. And sometimes I'll have to go, if I represent a hospital, I'll have to go to the doctor's attorney and say, look, I can't necessarily help you on some of these issues that your doctor has to deal with, but I won't hurt you, so do me the same courtesy. But there's some questions that you should not ask because it's probably not going to be what you want to hear, so I try to map that out to the extent I can early on and just say, here's where the real issues are going to be. And it's very tempting to try to get into that stuff. If you're, I've been doing this 25 years and it was routine. Back when I started for the OBs to just dump on the L&D nurses. That's just what they did, and everybody just sort of assumed that's what was going to happen. And what we found is if the OBs do a better job of saying, hey, look, I'm not sure what I would have done if they'd call me another time or if they'd said this or whatever, you've got a lot better chance of everybody riding through to a defense verdict in that case. Even when the physician says, yeah, well, they should have told me this and then I would have done that, counsel are smart enough and skilled enough to say, well, you kind of should have figured that out anyway. I mean, why weren't you checking on your patient? Why weren't you asking more questions? So, typically, if you can get the attorneys involved to agree, hey, look, no matter which way you go, they're going to exploit that. We have a better chance overall if we're all on the same page and we can talk about this tragic event that happened, but that everybody was acting reasonably and appropriately. And sometimes things happen that we just can't, no matter what we do, it's not going to change that outcome. But it's easier said than done. And once the cat is out of the bag, as they say, it's very hard to put it back in. I've had some doctors be able to come back at trial and say, I did say that at my deposition. That's true. However, since that time, I've been able to review the depositions of the other involved providers. I've been able to review the depositions of the experts, and I have to admit, I think they're right. I don't think that, under those circumstances, I would have elected to do a C-section because there was a maternal fever, because there was a danger, to the mother. And, there's ways you can do it, but it's better if you can do it on the front end, than the back end.
Jack, that been your experience? I know when I'm reading depositions or if I'm talking with doctors or nurses and they start wanting to point the finger, it stresses me out.
Oh, yeah. And it's hard because I think sometimes, it's definitely a trust factor amongst your co-defendant counsel. And we have good, in Georgia, we do, a lot of states have good protections on joint defense agreements. So you can just, if you need to have a written agreement in place about, hey, let's talk through these experts, let's talk through causation. We want to have a good picture, even if we've got some issues about whose job was what or who was at the bedside at what time. It's really a matter of prep, right? It's really not just of your clients, but when you're going in to take a deposition, like Jason said, like knowing if there's a question you shouldn't ask, or knowing if there's a question you're going to ask a co-defendant doctor that's going to, you won't be surprised if you just call their attorney and say, hey, how would he answer this? Because it affects X, Y, and Z. And so you can get a lot of trust that way. You can also really plant the seeds for efficiency for like sharing experts and, having a good damages picture and having causation experts if you need them. And so those initial calls are one of the most valuable things that we do. And of course, a lot of us work together pretty regularly. So you can get a reputation very quickly for being the person who kind of always blames somebody else and who proves plaintiff's case for them. And it doesn't help anybody. So we really try to avoid that if possible. And we've got cases where that requires a lot of work because the provider legitimately believes that, whatever it was, and would not have happened if X, Y, and Z, right? It's not just blame. They are like in a situation where they expect or whatever, and they're disappointed. And sometimes there's a little bit of disappointment in themselves, and that's a whole psychology issue. And there's deflection, and sometimes it's just a matter of truly like, here's what the hospital policy says, and that's why I expected or whatever. But feels like an objective, like, oh no, And if so, if you're in that situation, I think to the extent you can minimize it through prep and not paint plaintiff's case for them, that's a hard conversation. But a lot of times they'll come around and say, hey, you're right. I will just expand this whole situation if I give them all of my thoughts. And I always tell my clients, a deposition is plaintiff's opportunity to ask questions. It is not our presentation. It is not because they will feel like that if they go into a deposition thinking that they have to paint the whole picture and set the record straight. That's where you start to have those like anxiety inducing moments where you're like, oh my goodness, what is he still saying? So that so prep is so important. And the first prep begins when you first meet your client, that first meeting where they are learning that they've been sued or they were just served, but it's also important with experts. I know we've talked about experts a lot already today, but you can have an expert. It's important when you're going through your expert's initial opinion. Say you have just one provider, you have just the radiologist. But this guy might have thoughts on all sorts of stuff, right? It's important to make sure if your expert has problems with a co-defendant or someone else's care, or if they're going to stay away from that. And you prep them for how to respond to questions in a way that keeps them in their lane. That's good anyway. That's just good practice. But because plaintiffs can just become easy fodder when somebody starts to have overarching opinions. But you want to know before your expert gets in there and starts pointing the finger when everything else has gone smoothly. That has happened before, and it's again hard to walk back. It can be walked back, and you can ask your own questions of your expert. There are things you can do with that, but it's all about the prep. It's all about the mental approach to the case. And the providers, sometimes they start with their own hindsight bias. They start with they already know the outcome. They already wish something had gone differently, and they're trying to find a reason for that, right? So it's a matter of building them up and walking them through what they knew at the time, and walking back through the care. And once you do that, oftentimes you end up in a much better mental place and a better place to be deposed than if you didn't do that. So.
Yeah, Jason, Jackie had said something that made me think about when you talk about kind of this psychology behind what doctors, nurses, and healthcare professionals are going through. I think I found sometimes they can, because they're hard on themselves. They're strong-willed personalities. They're the helping personalities. Do you find them to be difficult to prepare for depositions because, to Jackie's point, they want to explain, they want to defend their care, they want to make sure that they get their stories across? What's kind of been your experience on that?
We spend a lot of time on prep. We've learned, I think, over the years, far better how to do that. When I started many years ago, the general rule of thumb was just say yes, no, or I don't know, and shut up. And we'll spring it all on them at trial, and it'll be great. And, that was back when you actually had trials a lot more often. And, the defendant could get dinged at trial when the plaintiff's lawyer crosses them and says, wow, it's your deputy didn't say much. And now you're very loquacious. You want to talk all the time. And it looks a little bit funny. But, I think it's better in their depositions if they can tell their story. They just have to do it the right way, because they do want to. But you've got to work through some of the psychology. So many of the doctors and nurses are, they've always been seeking perfection. That's what they have always done, and they expect that of themselves. And it's hard to get them reined back into, all you really had to be was reasonable. That's really the main issue. So how can we explain this in ways that you're not making it sound like you didn't achieve your expected perfection standard, which is impossible anyway. And it makes you sound like you did something wrong, even though you didn't. You were completely reasonable, but you sometimes are making it too hard on yourself and making it sound bad. So, and I know you do a lot of witness prep discussions, and I think that's kind of something that we've come to we've understood. If you do more of that, if you work through some of their issues, I think they've got a lot better chance of coming across as a considerate, compassionate provider that the jury is going to like. And if you get that impression to the plaintiff's counsel early in the case, preferably a day or two after you've really smacked the plaintiffs around in their own depositions, I think you set the tone for the case. And I've had a lot of cases where the case has gone away when the defendant gives her deposition because she explains, here's what happened. I care about my patients. I understand that there are concerns here. I'm not mad about it. I want to make sure you understand why I had to do what I did. And I think that goes a long way in prepping the case for whatever's going to happen, especially if it's video. That comes it comes across a lot better at trial than an evasive witness on video.
Yeah, good point. Jackie, I want to wrap up on one last question, kind of the elephant in the room when we're talking about med mal or really any cases. We're talking safety being a top priority, and how that Hippocratic oath tends to get used against medical professionals and how they tend to fall prey to the plaintiff attorneys focusing on a lot of this risk, safety, danger, harm, all of that aspects. So how do your approaching of that, preparing your witnesses for that so that they're, to Jason's point, not being evasive, but at the same time being aware of what's occurring, why the answer is not yes, because it's factually true that it's not yes, the whole aspect.
Yeah, we, there's the reptile book and a lot of people, it's interesting the background psychological safety based, that people have this reptilian aspect, and when questioned on safety, they'll always say yes. And when jurors hear there was a safety issue, they'll always feel like there was a violation. And it's really a conflation, right? It's a conflation of what the law actually says, because the law does not say anything in general in medical malpractice cases, especially about safety. The law says what a reasonable provider should have done with those patient specific circumstances. And so oftentimes I'll give them kind of silly examples, right? I'll ask that question. That's kind of a test question for any doctor or nurse when I'm first starting to prep them for their deposition. I'll say, well, tell me, here's an example cross question. You believe patient safety is the most important thing that should be in your mind at any time, right? And you say it in this very, it would be silly not to agree with that. And they sound like that. All of those questions sound like that. That's why they're so dangerous. And if you're just prepping them to Jason's point for yes, no, I don't know, really short answers, and they're never giving an opportunity or even being prepped for when they need to explain, then that can be so dangerous, right? So I try to use a silly example of, well, I mean, if I wore a helmet in my car, that would be safer, right? Well, do you think that's reasonable? Do you think that's way beyond reasonable? You think it's a little ridiculous? Well, we're going to have themes in this case that are like that, right? We're going to have themes that, whether it's your charting or whether it's, double, triple, quadruple checking, whether it's an additional test that should have been ordered. And so, yeah, those are safer, but if they're things that are not normal and they're not reasonable, and in fact, you go whoa, I don't know if that's even ever been done. Please tell me so we can work on defense themes that where we can call those things out. And in your deposition, it's okay to say things like, well, I don't think that's ever done at our hospital or any hospital that I know of. When plaintiff has this theme that's it always should be done, more should be done, more should be recognized earlier. So yeah, I think that safety is a very dangerous topic, ironically, if it's not prepped for, and especially in med mal cases, because patients go into a hospital or facility and just saying no, patient safety is not the most important thing to me is also a bad answer, right?
Yeah.
You have to explain, and you have to explain why. And so I try to use kind of silly examples like that, where I say, hey, reasonableness is the actual standard. And we do other things too, obviously, when we're getting a case ready for trial. If we've seen a lot of reptile theory stuff, safety questions, safety themed crosses of experts, we'll file motions in limine about conflating the legal standard, and that the legal standard is reasonableness, right? And we'll cite the statute, and the legal standard is not, the safest possible outcome. But so it's not just witness prep, but those are very dangerous questions, not just in med mal cases, in any case, but nurses, doctors, healthcare providers in general, they are inclined to agree that safety is important, and even the most important thing. Safety is not always the most important thing, actually. So when you talk through when that's not actually true, then they go, okay, they can understand that those can be tricks,
Yeah, Jason, what's been your experience on that too? And like I said, and then even to Jackie's point, sometimes an attorney will go reptile theory. Oh, what are you talking about reptiles? I don't even know what you're talking about. But you can hear, and maybe they're not using the needlessly endanger, unnecessary risk straight from the manual, but absolutely they're pounding on that kind of safety topic, right?
Absolutely. And I think that Jackie's point is a great one. And I'm actually going to steal the helmet in the car example. I like that. I think it's great. But the point is, I agree completely. You've got to break the spell, because there is such a danger. And, I have seen providers just look like a deer in headlights, like, well, what am I supposed to say? I mean, I can't sound stupid. If I say no to that, it sounds like I'm saying, yes, it's okay to beat your dog or whatever. And once you kind of, again, put it in perspective and break the spell, it's very powerful when a doctor says, hey, look, most of what we do is not safe. Every time I cut someone's chest open to go and take a look at their heart, that is not safe. It's never been safe. What we do, again, we have to be reasonable and do what we think we need to do to help this patient. We have to weigh the risk of that unsafe thing, cutting into that patient, against the benefit of getting down there to their heart or their whatever and taking care of the situation. I told you, I think before we started, I just tried an umbilical hernia case, and those are not supposed to go bad. Those happen all the time. They're supposed to be safe. It's like an appendectomy. Every once in a while, something will happen. And when you can tell the jury, look, I mean, this is not a safe procedure. This is a procedure that can be done in such a way that complications are less likely to happen. But no matter what you do, occasionally you're going to have a complication. And the key is to recognize it, take care of it appropriately and timely. That's where the real case is. And if you can kind of get them through that, you're being manipulated. And I've said that on occasion. You are being manipulated. Jurors, they're trying to do this. This is not what the law says. And this is not reality. It's not reality of what reasonably happens in these situations. And I think it gives you a great opportunity to build up your credibility and get a little bit of a side eye going on the jury toward the plaintiff's counsel when they realize, hey, that was good. I mean, you almost had me there. You almost made me think something that's not really what we're here for. And it's right there in black and white. That's why I put the instructions up on the screen for the jury. They don't have to take a slick lawyer's word for it. Here it is. And that is so much more effective when I can say, it's not me saying this. This is what the court is reading to you. But of course, when you get to that part of the instructions, their eyes are kind of glazed over anyway. But when you show them, and most of our courtrooms now have video monitors in the box where they can actually see it, and I can highlight it and underline and all that kind of stuff. I think that helps you put an end to that fiction where, like Jackie said, you're not going to see the word safe in any of these instructions. None of them, ever.
You mean safety? The safety rule? There's not a safety rule book. They don't give safety rule books out.
I haven't seen one yet. In Ball and Keenan's book, maybe, but you're not going to see it in the Arkansas model and jury instruction civil. I promise.
Yeah. All right. Well, this is great. I appreciate both of you coming on. I could talk to you guys for hours, but I'm going to wrap this up here. So, but I appreciate both of you coming on. Jason Hendren, Jackie Clark. Thank you for coming on the podcast. This has been another edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences.